Yes, Mr. Dennis.
May it please you, my lords, my lady. Before we took the break, my lords, there was a question which was posed, which I will answer at this stage, and perhaps I can break it down into two parts. So the question was, did the ECCB form the view from the investigations to which I referred, that what is being characterized at this stage as deposits were not, in fact, deposits? And the answer to that, my lords, is that this was not an opinion as such formed by the ECCB, but that is what was reflected in the books and records of the parent bank when it conducted its investigations. And that, my lords, is that's the answer to the first part of the question. The second part of the question was your lordship's question as to whether they were excluded because of that. And I say, in answer to that, my lords, they were excluded because of that, but that is not the end of the matter. Because as a matter of law, having regard to the statutory regime, they could not properly have been included. In other words, the central bank simply had no choice in the matter having regard to the statutory regime. As regards the first part of that answer, namely that this was not a conclusion arrived at simply as a matter of opinion by the central bank, but this is what the books and records of the parent banks reflect. I had indicated to your lordships that that is something which is reflected in the judgment of the...
Yes, but we'll let you take us to the judgment in just a moment. Can I just clarify what you've told us? You say that it was not an opinion formed by the central bank.
Yes.
But you say they were excluded because of that.
Let me clarify, my lords. It's not that the central bank simply arrived at an opinion that they were not deposits. Mm-hmm. What happened, what occurred was that when the central bank did its investigations, what it found in the books and records of the parent banks is that these books did not reflect them at all as deposits. They were never characterized as such. They were intercompany accounts. That is what the books and records reveal, that they were not deposits.
Sorry, could I clarify
Yes.
as to when they formed the view that the books and records had revealed that these were not deposits but were just intercompany transactions? When did they form that view?
Well, my lords, that would have been...
And isn't that a decision and being made by the central bank? Those are two questions. When did they make that? When did they make a decision that these were not deposits, in effect?
Okay, to take the first part of your lordship's question first, the intervention was in 2013, and it would have been during the early stages of the intervention that this became apparent. I am unable to say the precise date at this point in time, but it would have been during the early part of the intervention in 2013. So that answers the first part of your lordship's question. And if your lordship could remind me what the second part of the question was.
They made a decision to exclude on that basis. When was that decision made, and do you accept that it was a decision made by the central bank?
Very well, my lords. And that is where the second part of my answer... of course,
I do apologize, but I understood you to say they were excluded on that basis, and there were also other grounds to exclude them.
They were excluded on that basis, yeah. My lord, but that was not the end of the matter, because the statutory regime gave them no choice. Yeah. And I was going to take your lordships to that.
Well, the statutory regime, I mean, if it was correct that they were not depositors,
yes,
then the statutory regime gave them no choice.
Exactly, my lord.
Is that what you're...
Exactly, my lords. And that had
to really, they're not two separate reasons.
Well, but let's posit let's imagine a bank like the Appellants, but not a subsidiary of the two banks, the two parent banks, an entirely independent bank licensed to do offshore business banking. That has an account with one of the parent companies. Now, do you say that the money that it puts into that account would or would not be covered by the legislation?
If it is an entirely independent bank doing offshore banking business, then it would not have been possible for them to have paid those monies into an account with the parent bank, because the parent bank is not authorized to hold foreign deposits in foreign currency. It can only accept deposits in local currency. And that is why...
Yes, but suppose the licensed bank, independent licensed offshore banking business bank, wants to have its bank account with one of those companies. It puts the money in Eastern Caribbean dollars.
And that, my lady, would make the difference, because if it put the money in, if having received foreign deposits in foreign currency, it converts that into Eastern Caribbean dollars and deposits it in the parent, there's no problem with that, because the parents are allowed to carry on domestic banking business in domestic currency. The parent banks, however, were not licensed to hold deposits in foreign currency from non-residents of Anguilla. And that is the fundamental distinction between what would be an ordinary licensed offshore banking operation which receives deposits, converts them into local currency, and then puts them into the parent bank. There's nothing wrong with that because that does not offend the legislation.
Where's the evidence? Where is the evidence that the parent banks held this money in US dollars?
Very well, my lords. That would take me, my lord, to the evidence which was before Moise J, which showed that what was happening is that monies were being deposited into the subsidiaries, which was then directly being put into the parents in foreign currency, in circumstances where the parents were not so authorized. And that, my lords, if I could take your lordships to where that is set out in the facts which were accepted by the learned trial judge in that case where that was a live issue. Could I ask your lordships to turn up at page 2040 of the authorities bundle, 2039. And that was those were proceedings brought by the appellants against a number of defendants, including the Eastern Caribbean Central Bank, the conservators who were appointed, as well as the receiver.
Are these the civil proceedings?
These are the civil proceedings.
Forgive me, alleging breach of fiduciary duty.
And one of that is correct, my lord. And one of the issues in that case had to do with this very point about the characterization of these funds.
And this judgment was delivered in October 23
by Justice Moise on the 12th of October of 2023, in which he set out the facts which he accepted. And if your lordships turn to page 2024, and in particular paragraph 10.
2042, I think.
2042. He says there, it would appear from the evidence provided that the offshore banks had established no distinct corporate banking relationships with any institution other than their parent banks.
And when he refers to the offshore banks, is he referring
He's referring to the subsidiaries.
Even though I think it's common ground amongst the parties that they were not offshore banks.
This has been a difficulty throughout, my lords, because they have been loosely referred to as offshore banks. And as we made the point in our written case, that was not meant in a technical sense. That nomenclature was merely descriptive of the fact that the business in which they were engaged was to take deposits from non-residents of Anguilla in foreign currency. And that is the sense and the context in which the nomenclature offshore banks was used. And that is the context in which His Lordship in this judgment uses it. So he goes on to say, it would appear from the evidence provided that the offshore banks had established no distinct corporate or banking relationships with any institution other than their parents. The operations of the offshore banks were linked primarily to that of the domestic banks, on whom they were entirely dependent. There were no separate bank accounts or any relationship with correspondent banks outside of Anguilla. All of those services were provided within the corporate structures of the domestic banks. As I understand it, the offshore and domestic banks also shared a common directorship. It is also important to note that funds deposited by clients of the offshore banks were then placed in the intercompany accounts held at the domestic banks. According to the evidence presented, the offshore banks would keep a record of the individual depositors and their transactions in their own books. No distinct accounts were opened at the domestic banks for any customer of the offshore banks in particular. Each offshore bank held an intercompany account with the parent bank. However, those funds were not reported to the ECBCB as separate deposits, but were rather listed as other liabilities. There was therefore a commingling of the funds of the domestic and offshore banks. It was also not a point in contention at trial that this commingling meant that funds deposited by the offshore banks were upstreamed into the domestic bank's own funds. Hence, my youths, my lady.
Well,
Where does it say?
I'd say yes.
What foreign that they were done in? It was done in a foreign currency. That seemed to be.
My lady, may I complete the quotation, and then I will get to your ladyship.
And I've been reading on. I can't find it as yet, and I'd be grateful if you could point to the specific part of this judgment that identifies that the parent banks held the money in US dollars.
Well, my lord, the passage here speaks about those funds being upstreamed into the domestic bank's own funds. So this upstreaming, what this imports is that the monies which were received by the subsidiaries conducting offshore banking business were simply placed with the onshore banks.
No. The judge isn't saying that. He's saying, in a sentence that contains the word upstreamed, he's saying that funds deposited by the offshore banks, so the funds deposited by the offshore banks with their parents were upstreamed, as he puts it, into the parent bank's own funds. Well, that's normal. If I deposit money in my own bank account, whatever I deposit will be, if you like, upstreamed into the domestic banks, into my bank's own funds. They have it available to use in lending or investing or whatever whatever use they want to make of it.
The important distinction here, my lords, is that your lordships should bear in mind that what we are talking about here in terms of the funds which the subsidiaries received and upstreamed were funds in foreign currency.
Well, where does it say that? Where does it say that? And we want to know where it says that in this judgment.
That comes from the fact, my lady, that the subsidiaries were not conducting domestic banking business in domestic currency.
No, they weren't.
They were taking in deposits in foreign currency. So what they were upstreaming were the funds which they received in foreign currency.
Why do you say that?
Well, and I have a more fundamental point, and that is, your client, the central bank, carried out an investigation, made a decision that the parent banks were holding assets in a foreign currency, and there's not a jot of evidence to that effect from your clients.
My lords, would your lordship asking a question in relation to that?
Well, I just, the people who know, who have the information, are your clients. They carried out an investigation. They will know whether this money was held in a foreign currency by the parent banks. And yet, they've given no evidence to that effect. And they've also given no evidence that this was the reason why they excluded the appellant depositors.
Well, we say, my lords, that that was not the end of the matter, because the statutory regime would not have allowed them to do otherwise. Am
I correct in understanding that there is no evidence from the central bank to say that this money was held by the parent banks in a foreign currency?
Well, in these proceedings, my lord, there is no evidence in relation to that. There's no evidence from the central bank, because, of course, there was no evidence, because the central bank, as we know from the history of the proceedings, only actively participated in the proceedings at the level of the Court of Appeal. It did not file any evidence in opposition when the application for leave was initially brought.
And how about its duty to assist the court, to explain what happened?
Well, my lords, at that stage, as I indicated earlier, the posture which was adopted was that insofar as the issue of the grant of leave was concerned, those were proceedings which were typically dealt with on an ex parte basis as between the applicant and the court. And it was in the context of that that the central bank did not read any evidence in opposition and did not actively participate at that stage.
Where do we see that rationale is advanced as the reason for excluding the subsidiary companies from protection? Has that reason ever been advanced in these proceedings before today?
Well, my lord, not in that detail. The reason as advanced was that because of the because of the legislative regime.
I think that's a distinct point.
It is, my lord. So what I'm saying is that...
So as far as the explanation that you've just provided today,
yes,
has that ever been advanced as the justification for excluding the subsidiaries from protection? Has it ever been advanced in these proceedings before today?
No, my lords. It was not advanced in these proceedings. It was not advanced in these proceedings because having regard to the statutory regime, which was referred to by the learned trial judge at the leave stage, and it being apparent from that in any event that the statutory regime would have precluded it, that without more, my lords, would have justified the fact that these funds were not were not included
So is this
in the resolution plan. So
is this
for the purposes of that, I'm sorry, my lady.
Is this your case, that may have been the reason why the legislation was drafted, you say, in such a way as to exclude these deposits? But if it is the case that the legislation was drafted to primary legislation was drafted so as to exclude these deposits, then the reason behind that drafting, or the reason behind that wording of the legislation, is not something that's amenable to judicial review.
That is precisely my lady.
But you still have to, but legislation only bites if the facts are, as you say, the bank's investigations reveal, and if they're correctly characterized under legislation in the way in which you submit they should be. I mean, for example, an intercompany account might arguably be a deposit. You maintain it's not, of course. But if the facts are not as you put forward, the argument simply doesn't get started. But if the facts are as you say, then it's open to you to argue that those facts don't properly amount to the holding of a deposit, but it's some different arrangement.
Well, what actually happened in this case, though, my lord, is that the relevant books and records themselves did not characterize these funds as deposits at all.
Yes, but what is it that in the legislation that you say excludes these monies? Can you point to the relevant wording?
Well, my lady, I was going on to that in dealing with the second part of the answer to the question which was posed with reference to the Banking Act.
Yes.
And the relevant definition of banking business. If your lordships turn up the Banking Act, which is to be found at page 1782 of the authorities' record. And if your lordships turn first to the definition of banking business, which appears at page 1791 in the interpretation section.
And we need to bear in mind that you've used up your time already, so if you can move through the argument quite quickly, that will allow time for Mr. Knox to be heard after you, and then Mr.
Yes, my lord.
Piewski to reply.
Yes, my lord. Banking business, as defined here, means the business of receiving funds through the acceptance of monetary deposits which are repayable on demand, frequent sale or placement of bonds, use of such funds either in whole or in part or for extension of credit, any other activity recognized by the central bank as banking practice and which a licensed financial institution may additionally be authorized to. So this is how the Banking Act defines banking business. And then it speaks about the acceptance of monetary deposits which are payable on demand. Now, having regard to the fact, my lords, that what the investigations revealed in the books of the onshore and offshore banks, having regard to the fact that those books revealed that they were not deposits but were rather intercompany transfers, and I took your lordships to the facts found by Moise J. in that regard. If they were not deposits, then they would not have fallen within the scope of the Banking Act and would not have fallen within the category of liabilities which were subject to be included as part of the purchase and assumption agreement and as part of the resolution plan. In other words, my lords, the simple point is that they were not deposits because they were not even so characterized by the parties themselves who are now asserting that they are deposits. And if they were not deposits, to the extent that the Banking Act 2015 made provision only for deposits to be protected. And since these were not deposits, and the appellants were saying so themselves, they did not fall within those protection provisions. And so, my lords, that is why we say.
And that was the case regardless of this other problem about what currency they were in.
Precisely, my lady, precisely.
But this case also has never been made before.
Well, as I said, my lord, the case was not put in this way and to that extent because one was simply relying on the statutory regime which excluded these deposits, in quotes. It is the statutory regime.
Right.
You say,
when you say statutory regime, what you're talking about is the meaning of banking business, or is there some other provision in the Banking Act or one of the other pieces of legislation?
It's my lady, that provision to which I took you.
That's it.
And it is also, my lady, what is reflected in the banks. It is also the legislation to which we point out. I'll just take your ladyship, your lordships, to the relevant section of our case in the interest of time, just to point you to where we deal with that. We set out the relevant legislative framework which your lordships will find at page 1745. Of our submissions. And that sets out the legislative framework. And having set out the legislative framework, my lady, we go on to set out what the appellants contend, and behind that we set out what the ECCB's and the receiver's position are. And then, culminating at paragraph 62, where we speak to the statutory regime and why that statutory regime would have excluded these deposits. And we say...
That's a different point.
Yeah, well, I was just giving your ladyship the full context of the applicable statutory regime. But for the purposes of my last submission, the particular statutory provisions which are germane would be that definition of banking business which we speak to, and the fact that it makes specific reference to deposits. And since what was found in the books of the appellants was that these funds which they're speaking about were something other than deposits, they would not fall to be included as part of the resolution plan, because the resolution plan provided for deposits to be protected.
Do we have the accounts of the, an example of the accounts of the NBA? Papers?
I do not believe we have accounts, my lady. I believe there may be audited financial statements. I would have to double check just to make sure.
Yes.
Yeah. Page is that? 100? Page 116, that's of the electronic bundle. 118, the electronic bundle, my lady. That's where it begins at any rate.
Now,
my lords,
you've only got a few
yes, my
minutes
lords,
left, I'm afraid.
That is the gravamen of our position, and having regard to the time, I believe, my lords, the other matters, your lordships would have been able to deal with based on the contents of our written case. And so, unless there is anything further I can assist your lordships with, I'll be happy to take my seat. And I should just point out, my lords, the consolidated financial statements of the National Bank of Anguilla, which is one of the parent banks, that is found at page 175 of the electronic record.
Is it the case you're not relying on the administrator point, which was made by the judge?
Well, we are, my lords, but in the interest of time, I will simply rely on what we say in our written case in relation to that. We are not abandoning anything in our written case because I have not addressed it orally in the interest of time, except to say, my lords, and I can say that at this stage, that we are not pursuing the alternative remedy point. But apart from that, your lordships may take it that we stand on all our other submissions as disclosed by our written case.
And before you sit down, what is it? I'm just looking at the accounts of the National Bank of Anguilla, perhaps on page 178 is perhaps the relevant page. What is it you're drawing to our attention? Is it, I don't know, is it perhaps to do with the entries for deposits from customers as compared with other liabilities? I don't know.
Your lordship is taking me to what page, my lord?
Well, I don't. I'm just taking a guess. You said that you're referring us to the accounts of the parent company, which begin at page 175, and I'm wondering what in particular in the accounts you want us to look at.
Yeah, I think it was actually, to be fair, it was I asked
Yes.
for those.
Yes.
And why I asked was to see whether there were other subsidiaries of the National Bank of Anguilla, which it seems that there are, if one looks at page 180. And so I wondered, but you may not know the answer to this, whether if they had deposits with...
My lady, there were no other subsidiaries of the parent banks.
Okay.
The only subsidiaries of the parent banks were the two subsidiaries who are the appellants in these proceedings.
I don't think that's quite right, is it? There's a reference to other subsidiaries on page 180. The pension funds company is a wholly owned subsidiary. The National Tourism
Oh, well,
investment
my lords, I understood the question to be specific to whether there were subsidiary banks.
No, I was asking whether there might be other subsidiaries who also had a bank account with the NBA.
Oh, I see. I misunderstood your ladyship's question. Yeah.
Right.
And these are what we're looking at. We've taken us to our consolidated accounts for the entire group.
Yes. Well, my lady asked whether there were any accounts, and those are the only accounts in the records to which I could.
Right. So we don't know how, if those other subsidiaries, if they also had a bank account with the NBA, we don't know how those were treated.
No, my lady.
As far as this application of this legislation.
No, my lady. I'm afraid I wouldn't be in a position to assist your ladyship on that.
Okay.
It might be that they are one of the people who benefit from the trusts that were set up, because there was a reference, I haven't got it immediately, to a pension fund being a beneficiary in one of the trusts. And whether it's this pension fund or whether it's some other pension fund, I don't know.
Yeah.
But I suppose that's just an aspect of a case being presented without much evidence to support it at the moment.
Well, I think, Ms. Dennis, we better thank you and let you sit down so that Mr. Knox can have time to address us.
Would you like this?
My Lord,
Well,
I have three main points. First is on the deposit protection trusts. My submission, the government had no choice but to enter into the deposit protection trust with the investors whose deposits had been transferred to the new bank under the purchase agreements. And correlatively, I say it could not properly have required that the appellants' deposits be included in those trusts or refused to execute those trusts unless the appellants' deposits were. That, I say, follows from the terms of the legislation itself and is clear, tolerably clear, and not something which would require the matter to go to a full judicial review. Second, the exclusion of the appellants from the purchase agreements by the receiver, even if wrongful, does not give rise to a legitimate ground of challenge against the Chief Minister for making the vesting order. That is because the domestic depositors who were included in the transfers under the purchase agreements were all entitled to be so included and in the sums so included. The relief in relation to the banking vesting order is for the appellants, if the purchase agreements were wrongful, is not therefore against the government, but against the central bank and the receiver. And that relief would be, please reconsider your decision to exclude the appellants from the protection of having a transfer of assets and liabilities to the new bank. The third point, which is related to the point I've just made, is that there is in reality no practical relief that could possibly run against the government or the government respondents for two reasons. First, there is in fact no application, as I read the judicial review application, to set aside the deposit protection trusts or indeed the transfers made pursuant to the purchase agreements. There are, of course, complaints about the decisions that are made, and I can give you the reference in the interest of time rather than take you to it. There are just the decisions, there are criticisms of the decisions, first as to what is to be included in the Deposit Protection Trust, and there are, of course, complaints about the decision to make the purchase agreements or to limit the purchase agreements to the domestic depositors. But there's no application, and in my submission, understandably, no application for an order that the deposit protection trusts be unravelled, or likewise that the purchase agreements be unravelled. That's part one. And the other part is, even if there had been such an application, the passage of time would make that completely unthinkable. There's no dispute that from the moment the new bank started operating, which I think was the 25th or 26th of April 2016, it has been and had been operating as a perfectly normal bank, protecting the depositors who have had their deposits transferred in the normal way. And all the banking vesting order did in practice was to formalise an arrangement which had long since been arrived at. Therefore, I do submit, as far as the government is concerned, one asks, what is the point of the government being in these proceedings at all? The remedy, and the only sensible remedy, is against the central bank, if they have acted wrongfully, or the receiver, if he has acted wrongfully, along the lines I've mentioned a moment ago. Please reconsider your decision to exclude the appellant's deposits. And if it was unlawful, please take a decision which will have an impact on that. If I can turn can I just make a preliminary point about how to construe this legislation? There's one important point which I submit one must bear in mind, and that is about the role and powers of the central bank. This is essentially a supranational bank with responsibility for maintaining the financial stability amongst the 8 participating governments in the Eastern Caribbean and for ensuring the stability of the currency. That is a fundamental point. So this is, so to speak, one has to construe the government's responsibility in the light of this, what you might call, supranational body, which has got a specific responsibility for stability of the currency and stability in finances. And that, I submit, explains why the central bank has the extensive powers which you find in the Banking Act. And if I can just very briefly take you to the relevant provisions in the Banking Act, in the Central Banking Agreement Act, which you can find at 1970, if I can just canter through them, which just make good the points of the extent of its powers. You have, it's at 1970 in the electronic bundles, where I think the Act, the Central Bank Agreement Act, begins. It was passed in 1973, thereabouts, 83. And you can see at 1970, this is the 1973 Act. It has had some amendments, but nothing of any great significance. Halfway down the page, agreement to have the force of law. The agreement has the force of law in Anguilla from February 1992, and then the agreement itself begins on 1973 as a schedule to the Act. And at 1978, you can see clause 3, the establishment of the bank, and then clause 4 sets out the purposes of the bank to regulate the availability of money and credit, to promote and maintain monetary stability, and then conditions for a sound financial structure conducive to the balanced growth and development of the economies of the territories of the participating governments, and so on, to actually promote the development. Then clause over the page, 1980, clause 5b. These powers have been slightly amended, but this is, you'll see the powers of the bank, where the bank is of the opinion that the interests of depositor or creditors of a financial institution are threatened, is likely to become unable to meet its obligations, not maintaining high financial standards of probity. Then, in addition to various other powers, it has a whole series of powers to investigate.
Is this legislation effectively implementing the international treaty in the domestic law of Anguilla?
Correct.
Yes.
Correct.
And clause 7, I think it's 1985. And obviously, I'm just picking out one or two bits, but clause 7, administration and management. There shall be established a monetary council which will consist of one minister appointed by each participating government, in such manner as it may determine. Each such minister shall designate an alternative, and then it has to meet twice a year. And then finally, 1990, page 1990, clause 18.1, the bank shall have the sole right to issue currency notes and coins and so on. So this is that the central bank understandably has very considerable powers under the Banking Act. And I just make this point generally. It is not the sort of act where the government reads the act as one where the government can just, as it were, say, oh, never mind about that recommendation. Because these recommendations really matter. They're in the interests not just of Anguilla, they're in the interests of the entire currency union. I'll come back to that point later, if I may. Now, the first point is about the Deposit Protection Trust. And what is said against my clients is that they made a decision to exclude the appellants' deposits, or at least I think it's been suggested that they could have refused to go along with the suggestion that the appellants' deposits should be excluded. And I say that isn't right. That it's simply, under the legislation, that was not the government's responsibility. And if I can go first, just mention the chronology. The Banking Act was passed by the House, by the Assembly, on the 19th of November 2015, that's at 1817, assented to on the 18th of April 2016, and gazetted, and therefore came into force, on the 19th of April 2016, and that's those last two references at page 1790. The Bank Resolution Obligations Act was passed by the House on the 30th of March 2016, that's at 1781, and assented to on the 18th of April 16, and gazetted on the 19th of April 16, and that again is at that's at page 1777 of the bundle.
It came in force
19th of April.
Thank you.
The the purchase agreements were made on the, I think I'm right in saying it's the 22nd of April 2016, and it was not until, I think I'm right in saying, June 2017 that the Deposit Protection Trust was set up, sometime later. Now, I just want to make 2 points about the legislation. First, and my lords, my lady, you're familiar with this, but it puts the responsibility for deciding what assets and liabilities were to be transferred from the old banks to the new bank into the hands of the receiver, answerable solely to the central bank. And the government plainly had no role at all to play in this. And can I ask you please to go to page 1798 for section 140, subsection 1.
What page again, sorry?
1798. Central bank oversight of the receiver. The receiver shall act in accordance with regulations made pursuant to section 182 and so forth, the directions, prudential standards issued by the central bank at any time in the course of the liquidation, and shall be accountable only to the central bank for the performance of its duties and the exercise of its powers as receiver. That, in my submission, excludes unequivocally the government. Then you have section 142, transfer of assets and liabilities. The receiver may transfer any asset or liability of the licensed financial institution or licensed financial holding company without obtaining any approval, and so forth, with respect to the transfer of assumption. And then subsection 2, the receiver may, upon the prior written approval of the central bank and according to its directions, pursue the following activities: dispose of part or all of a licensed financial institution's or holding company's assets and liabilities through a purchase and assumption transaction. And again, it is clear that this is a matter for the receiver and the central bank. It is not a matter for the government at all what the receiver does when entering into the purchase agreements. I should say, my lords, my lady, it is not clear from the relevant document, which we do have, which of the particular powers in section 142 the receiver purported to exercise. You'll see there are various subcategories. He just says, I think I'm right in saying from recollection, pursuant to my powers in section 142. But I should say that the evidence appears to be, and I think we mentioned this in our case, that the evidence is clear that the new bank, as it's called, was, quote, a bridge institution, which you will see, a bridge financial institution, which you will see referred to in subparagraph B. And I don't think for the moment anything turns on that. Now, likewise, section 152 sets out a little further on, which is at 1804. Section 152 sets out the priorities in payments of claims to be made by a receiver. 152.1, in a liquidation of a licensed financial institution's assets, quote, allowed secured claims shall be paid to the extent of the realization of the security delivered to the secured creditor. 2, other allowed claims shall be paid in relation to all other debts in the order described below, and then you have a specific order in fairly standard form. But you then find subsection 6 on 1805, notwithstanding subsection 2, the central bank may take actions that would treat similarly situated creditors differently, but only if the central bank determine A, the category of claims that are benefited by the action are of strategic importance to the economy, or the action is necessary to contain potential systemic impact to maximise the value for the benefit of all creditors as a whole, and so on.
B is also important.
B, yes. No creditor will receive less in the liquidation than it would have been without the disparate treatment. C and 7 for the purpose. Now, the point I emphasise there is, again, along the same lines, this is entirely up to the central bank. This is just not the government's remit at all. And I submit it all goes back to the point that the central bank has to protect the currency union between different governments. So one individual, that is why the government has nothing to do with these things. It is the central bank who decides. Now, the second point about this legislation is, I submit, that it does presuppose, and I submit tolerably clearly presupposes, that the only people who are going to be protected by the deposit protection trusts are those who have deposits which exceed the amount which is transferred to the new bank under the intended purchase agreements. And it is not intended to provide for the protection of those whose deposits are not going to be transferred at all to the new bank, such as the appellants. And I say 2 points support this. First, if one looks at the Banking Resolution Act itself, and that, I think, is at tab 2, and it begins at 1776, you'll see the preamble. An act to make provision for the government of Anguilla to make payments to the Social Security Board and Deposit Protection Trusts in support of the resolution of the National Bank of Anguilla and the CCIB, the other one. Can I just mention 1 point? The reason the Social Security Board was included is that, as I understand it from those instructing me, the Social Security Board had very substantial deposits at these 2 banks, and so it was necessary to fill the gap for that purpose. And then you see in the definitions, depositor protection trusts means the 2 depositor protection trusts to be established and executed to protect as benefit.
You're reading.
Sorry. I'm reading page 1777.
Got it. Yep.
Yeah. I've just got to be established and executed to protect as beneficiaries the large depositors of the National Bank of Anguilla, of the 2 banks, the 2 old banks. That's the purpose of these trusts. To protect, quote, the large depositors. And
are they defined anyway?
No. But I say one can tell who they are. At the section 2, you can tell, section 2 provides, section 1 in the interpretation provision, resolution of NBA and CCB means the resolution of the 2 old banks to be implemented by the central bank, the government, and the Eastern Caribbean Association in accordance with the Banking Act. And so that's the resolution, and that the purpose of this is to bring into effect the resolution. And then section 2, the government shall pay to the Social Security Board and the Depositor Protection Trust the sums set out in Schedules 1 and 2. Now, the phrase, the resolution, is not further defined in this statute. But I submit it is quite plain from the background, and everyone will have understood what was meant by the resolution, because this was a problem that had been going on in Anguilla for about 3 or 4 years, 3 years, I think, by this point, and a resolution plan had been come up with. And you can see, in general terms, what the resolution plan, in what we might call layman's terms, what the resolution plan was, from the Chief Minister's speech, which he made, I think, on the 26th of April, thereabouts. Sorry?
22nd.
22nd of April, at the same time as just after the legislation came into force. And you can see that in the electronic bundle at page 752, halfway down the page.
Do we have a copy of the actual plan, resolution plan itself, rather than what the Chief Minister says about it?
My Lord, no, not in the... I'm not sure if it was ever actually committed to writing, but even if it was, we don't have it in the bundle.
Is it 752 you're taking us to, Mr. North?
752. Sorry? It starts on 751. I'm sorry, you may have been taken to this in a different page by my learned friend, and I apologise. I've worked from my client's exhibits. It begins at 751. You'll see, well, to answer my Lord Stephen's point, you'll see it says at the top in 751, issued 22nd, 2016. But you can see how it is put here. Fellow Anguillans, you'll recall the Central Bank Act, the Central Bank, after consultation with the Monetary Council, including the Chief Minister, was directed to assume control of the 2 old banks in August 2013. The objectives of the action were, and then 3 objectives are set out. In particular, 3, ensure the stability of the banking system in Anguilla and, by extension, the entire currency union. He then goes on to describe what had happened since August 2013 at the foot of page 751 and at the top of 752. He says in the second paragraph, the new Banking Act, which is one of the key tools in the resolution of the 2 old banks, incorporates international best practices and provides for, sets out certain things. And then halfway down the page, at its 81st meeting on the 4th of February 2015, the Monetary Council took the decision to provide full protection for all depositors of the CCB and MBA. That meant that whatever resolution and strategy was adopted, depositors would not lose any of their funds held with the 2 banks. And then, after careful and comprehensive analyses of the challenges affecting the operations of the 2 old banks, the Monetary Council and the government agreed that discontinuing their operations was the best option for safeguarding the deposits which were held at the banks. The government of Anguilla and the central bank, supported by IMF, the World Bank and CDB, devised the plan, and this is the point I want to emphasise, so that domestic depositors will be protected following the resolution.
Domestic deposits, it's actually.
Sorry, deposits, yes, deposits. Forgive me, my lady. And then A, good assets and matching deposit liabilities up to a threshold of approximately 2.8 million EC dollars from both the old banks to be transferred to a bridge bank. That's the new bank. Then deposit liabilities over the 2.8 million threshold from both banks to be transferred to a deposit protection trust. Over the page, as part of the resolution process, the central bank has approved Mr. Moving as receiver. Then next, the government of Anguilla is of the view that the deposit protection trust is the best alternative method, and I emphasise this in particular because it fully protects customer deposits. This fits with our principal objective. The alternative being placed in the Deposit Protection Trust is to be put in the receivership. In the receivership, claim holders are entitled only to the proceeds from the liquidation of non-performing loans based on their position in the hierarchy of claims as established by this Banking Act. And then dropping down to the penultimate paragraph on 753, the The new bank was incorporated in December 2015, licensed by the central bank. It was established for the sole purpose of purchasing and acquiring assets and liabilities of the two old banks to protect depositors and to ensure the continuity of indigenous banking services, and so forth. Now, of course, this doesn't say in terms that the purpose of the resolution plan was to exclude foreign deposits, but the thrust of it, I submit, is plain. It is to protect domestic depositors. So that's, I submit, one indication of what the resolution plan was. And in practice, it is inconceivable if the purpose of the resolution plan was indeed to protect what you might call the appellants' deposits, that within a couple of days the receiver is happily excluding the appellants' deposits. So I do submit one can draw from this the inference that it was never intended that the appellants' deposits with the old banks were going to be protected. That is because they were in essence derived from deposits from offshore deposits in foreign currencies. But there's a second indication as to what this resolution plan was and what is intended by the Banking Resolution Act. And that is a point which I think has been picked up by the board already this morning, namely, there is only a rather small fixed amount which the government is required to put into the deposit protection trusts. That is to say, the sum of $52 million. And that you get at page 1778 in the Bank Resolution Obligations Act, Section 2. I referred you to this earlier, but didn't take you to the schedules. The government is to pay Social Security Board and the Deposit Protection Trust the sums specified in Schedules 1 and 2. So you go to Schedule 1, and you can see the payment terms for the Social Security Board. It's a handsome $214 million, and there are provisions there for how the interest is to be worked and so forth, and how long it is to run for. And then Schedule 2, payment terms for depositor protection trusts. The government of Anguilla shall pay the depositor protection trust the aggregate, I emphasize, of 52 million EC dollars. Out of the aggregate principal sum, each depositor protection trust is to be paid a proportionate amount to its obligations to the large depositors there again of MBA and CCB as beneficiaries. And then the provision for government to pay interest in a 10-year term. Now, I respectfully submit that it is plain that the intention of this Act is not to include the appellants' deposits. And that is because it is common ground that the appellants' deposits totaled about $60 million US dollars, which comes to about 260 million Caribbean, EC dollars. And this sum makes sense, of course, when you limit it to domestic depositors. It makes absolutely no sense.
Well, do we know that? I mean, do we know what the domestic depositors?
Well, we do know what the domestic depositors came to because we can see a schedule of what was eventually we can see from the deposit trusts eventually set up a year later. We can see actually what the amounts were.
And what was it?
They seem to be a bit more than 52 million, but I think more in the region of 54 million or 55 million. But it's in that range, and the difference may be accounted for. I'd have asked, but the difference may be accounted for by the running of interest between the passing of this Act and the later setting up of the Deposit Protection Trust. But we can tell, what we can tell, I respectfully submit, is one, that the appellants' deposits were plainly not intended to be covered. The sum is simply on a completely different scale. Then you look at the deposit trust actually eventually set up, and for that, if I may, one can see that at page 768 of the electronic bundle.
Which page? Sorry.
768, my lady. Well, it begins, yes. You can see one of the deposit protection trusts for the NBA, and you can see, top of the page, title, this trust deed is made on the 30th of June 2017. The same, I should say, the same applies for the other company as well. They're in the same terms. And then you move, there's a preamble, I should draw your attention to preamble subsection 6 on 769. Government, pursuant to consultations with the Central Bank, enacted the Resolution Act, pursuant to which the government undertook to pay into the Deposit Protection Trust sums specified in Schedule 2 of the Act for the benefit of large depositors of the financial institution and CCB Limited that subsequently deemed to be those having deposits in excess of 2.8 million. So it rather looks as if at the very moment the statute was passed, they hadn't quite worked out whether it should be whether the limit should be 2.8 million or a slightly lower figure or a slightly higher figure. In support of the resolution. So, and then you find in Article 2, near the foot of the page, 769, the purpose of the trust. The purpose is to receive payment from the government under the Resolution Act in respect of the financial institution and to hold the same in satisfaction of the obligation for deposits set out in Schedule 1, which were formerly held by the primary beneficiaries in the financial institution, that's to say the NBA, in accordance with the terms of the deed, and the primary beneficiaries are defined on the next page, about a third of the way down. Primary beneficiaries shall mean the individual entities who are the owners of the deposits set out in Schedule 1. And then you go to Schedule 1, which is at 775, and 776, and you can see one figure, which is for the National Bank of Anguilla, the old National Bank of Anguilla, DPT holders, and it comes to $23.9 million odd. And then another is at 776 for the other bank, the CCIB as it's called, 32.9 million, which I think actually comes more like about 50, well, not far short of 57 million, in fact, as opposed to 52. So what I submit one gets from that is that it must have been decided, and it's implicit in the legislation, that the appellants' deposits were not to be covered by the deposit protection trusts. Hence the figure of 52 million is absolutely too low on any normal reckoning. And therefore I say, on a proper view of the legislation, taken in particular together with what the resolution plan was understood to be, the appellants' deposits were not intended to be covered by the deposit protection trusts. Therefore, importantly, there was nothing the government could have done in June 2017, when it's obviously being a party to these trusts, nothing the government could do either to insist upon the appellants' deposits being included in these trusts. And indeed, I go this far. It would have been unlawful for the government to do that. It would have been said, what on earth do you think you're doing? The statute sets out what has to be done. But there's another consequence which, of course, follows from this. Well, I don't specifically rely on it, but I do make this point as well. It is presumably implicit, in fact, in the legislation that the relevant purchase agreements were not going to transfer the appellant's liability, the appellant's rights. Because if they were going to include the appellant's rights, then the appellant's rights would have been included in the deposit trusts as well. So I do submit one has to look at this legislation realistically. But I don't need to rely on the point I've just made about the purchase agreements. I simply say that it was evidently the intention of this legislation, which you can work back, if you like, from the figure of 52 million, that the appellant's liabilities, or rather deposits and so forth, were not to be included in it. So that's my first point, the deposit protection trusts. There can be no criticism at all in my submission of the government's actions in relation to the deposit protection trusts. And it's all very well my learned friend saying, oh, but they have sanctioned an unlawful act. Well, first of all, I don't accept that. But secondly, they have done what they had to do pursuant to statute. And that's an answer to it. Now, the second point is the vesting order. Now, there are just four. If I can summarise the 4 points I take briefly on that, I'll deal with them, I hope, relatively quickly. First of all, there's a procedural point about whether the 2020 vesting order is in challenge or can be challenged. Secondly, there's the question of whether the Chief Minister had any relevant discretion over the matter, whether or not to execute the order. Thirdly, there's the question of whether, in any event, if he did have discretion, there was any irrationality or illegality in his making it. And then, fourthly, the point, was it necessary in any event? What does it add? Now, just dealing with the procedural point, we say that the only challenge on the vesting order in the courts below was on the basis that the judge had wrongly held that a vesting order had not been made when it was being argued it had been made. That was actually the argument both before the judge and in the Court of Appeal. It doesn't appear to have been argued in the Court of Appeal, oh, hey, I now want to make a challenge to that vesting order that's now been made. I'll explain why I say this is not a mere technical point. So in other words, the challenge was, in the Court of Appeal, the judge made a wrong decision in relation to the existence or non-existence.
I'm sorry, you said that. What was the only matter which was challenged?
Well, what was the challenge in the Court of Appeal was simply this. The judge wrongly rejected my submission that the vesting order had been made by the time of the hearing in front of him. That was the submission being made. And that is why, when you look at the judgment, the Court of Appeal's judgment, quite a lot of it is dedicated to saying the judge got it right. There was no vesting.
It's a matter of the timing of the vesting order we're talking.
Yes, and that essentially was the attack that was being made in relation to the vesting order in the Court of Appeal. The judge should have held one had been made, and the Court of Appeal reject that. And the passage in which they reject it, I think, it begins at page, I think it's 1405 of the electronic bundle. I can just, yes. I'm not going to ask you to read all of this, but the reference begins, if I can put it this way, at 1405, para 101, my lord.
Of the Court of Appeal.
Court of Appeal. It's in the key documents bundle as well, at tab 6, I believe. Page 42 at the foot of the page. And the Court of Appeal here, the context is the arguments about the vesting order. Then the Court of Appeal says in 101, I've already mentioned the appellate court's reluctance to override trial judge's discretion and so forth. And it then continues all the way, paragraph 102, perhaps I should just show you this. The appellants have not refuted that the Chief Minister made the vesting order under the Act on the 26th of June 2020, only after the learned judge below, had considered their application for leave. They presented no evidence that he made an earlier BBVO in respect of the transfer of the banking business undertakings from the parent banks to the new bank. This belies their contention that the Chief Minister had made a vesting order when they made their application for leave. Moreover, it discredits their case that he unlawfully made a vesting order which accorded them different treatment. That was administratively inconsistent and so forth. And then they continue in similar vein especially until you get to 108. Similar effect. Page 45 at the foot of the page, or 1408 electronically. The learned judge's determination that the absence of a vesting order by the Chief Ministers created a situation where the appellants had not presented a decision to the court which was susceptible to judicial review, cannot be faulted. In fact, in law, that was the only reasonable conclusion open to him. And so, in similar vein, it carries on until you get to paragraph 109. So that's how the matter goes in the Court of Appeal. There's no specific, as it were, challenge to the making of the June 2020 vesting order. And I do submit that is actually not an academic point. Because if a challenge is to be made to the vesting order made in June 2020, it is one which is being made is being made to a vesting order which is made 4 years or so after the new bank has been in operation, 4 years or so after the transfer of all the relevant deposits to the new bank, and after the central bank has made a recommendation for the vesting order after that passage of time. And that, in my submission, would inevitably require different evidence from that which is currently in the case. In particular, one would be asking, how could it be said that in the circumstances in 2020, given the passage of time, the Chief Minister acted irrationally or ultra vires or unfairly in acting on the recommendation, whatever might have been the position had he so acted earlier?
Because you say because if he'd refused to make a vesting order, that would have thrown in doubt everything that had happened, because they were all treated as vested, in fact, for that.
I mean, but one asks rhetorically, well, what was he supposed to do by then? I mean, and you've got the central bank recommending it.
Do we have a copy of the recommendation from the central bank? Do we have any evidence about the recommendation from the central bank? Does the recommendation from the central bank deal with the points that you're now making?
No, my lord, the last point I cannot say, but it's not in evidence. I think we do not. It's not in the record. It wasn't put before the court. But of course, my lord, one of the problems with this is this wasn't a point taken in the Court of Appeal. So I accept your lordship's point. But this particular, but there was no challenge to the 2020 vesting order in the Court of Appeal as such. And there was no application to amend, say, well, I now want to amend so that we challenge the 2020 vesting order.
Well, there certainly is a challenge today to the 2020 vesting order, and one would have thought that the recommendation from the central bank, which you say is really highly persuasive and can't be gone behind, should be made available.
Well, my lord,
I'm just wondering why it hasn't been.
Well, my lord, I cannot answer that question. I would need instructions as to that. But, my lord, I simply, just going back to the Court of Appeal's judgment, I submit that the judge was plainly right to hold, or the Court of Appeal was plainly right to uphold the judge's finding that no vesting order had been made. My lord, my lady, the second point I want to make is this. Was there a discretion, or at least what was the limit of the Chief Minister's discretion? For that, one needs to go to section 140. Sorry, section 100.
As to whether to make the vesting order.
Yes, yeah. Does he really have a discretion? Well, if so, is it an open or at least very narrow? Sorry. Right, sorry.
That would depend upon the recommendation that was made.
Well,
you'd have to see the recommendation to see whether or not it gave him any discretion whatsoever.
Well,
and you've chosen not to make it available.
Well, my lord, can I just... I understand your lordship's point. Can I ask you to look at section 174, subsection 3, at page 1808? And the way it is worded, section 174, in my submission makes it plain that the Chief Minister is expected, to put it at its lowest, is expected to act upon the recommendation. You'll see 174.3, on completion of the investigation, the central bank's investigation, central bank may, if it thinks fit, make a recommendation to the Minister to make a vesting order, transferring to investing in the transferee financial institution the undertaking as from the date specified therein, and on the making of such an order, all such existing property rights and so forth shall be vested. So,
how could, without this vesting order having been made, how could the bank, the new bank, be dealing with all these assets? They weren't vested in it.
My lady, that would appear, that goes back to section 142 of the Act, which is at page 1799, which in my, I did show you a moment ago. Yeah. There is a power there to dispose of, and my lady, one interpretation, but I don't urge upon the board now to decide, but one interpretation is that when the receiver makes a transfer on the central bank's say so, then there is a transfer, and by implication, all the assets and liabilities vest in the new bank, and third-party rights likewise transferred to and against the third bank. Sorry, the transferee, the new bank.
But you have to read the Act as a whole, and it's difficult to read. It's lex specialis and lex generalis, isn't it?
Well, My Lord, I don't want...
That's the argument.
Yeah, yes. If you go back to section 174, all I'm saying is it's not an intolerable, it's not an insupportable argument, because 174 is premised not upon a transfer by the receiver as such. It's premised upon when you've got a transfer from one bank to another bank. It's not specifically talking about receivership. Now, one way of reading it is to say there are two separate regimes. Another way of reading it is to say that where the receiver does execute a transfer, then to the extent appropriate, there can still be a vesting order. The reason I emphasise this is because when you read 174.1 and 2, it's quite plain that there's a specific procedure for the central bank to make all sorts of recommendations in section 174.1 and 1, 2 and 3, which are inapplicable when there's a receivership. And when there's a receivership, the central bank will have already made its investigation, and then the receiver does the transfer. Here, it's the other way round. You have the agreement, and then you get the central bank to investigate.
Right, but 174 is not necessarily dealing with an insolvency.
Yeah, not necessarily, yes. Now, I'm not for the moment, I'm not saying that the vesting order couldn't have been made or was totally unnecessary. That's not, I'm not for the moment pressing upon the board that submission for decision today.
But you're saying that had anybody in that 3-year period said, wait a minute, you actually don't own all those assets, because there's been no vesting order, the argument they would have had to fall back on was, yes, we do, because of 142.
Exactly. Correct. Yeah. So that's my answer to that. But just going back to section 174.1, I do submit that it doesn't say that the minister has a power to act upon the recommendation. It doesn't say the minister has a duty to act upon the recommendation. It just rather assumes that he will. It seems to be taken for granted. That's why I say that the minister either must, or at least if he's not going to do so, he has only a limited discretion not to do so. For instance, if the recommendation was in some way dishonest or somehow manifestly insupportable. But otherwise... The
implication of subsection 5 is that the minister has a discretion as to provisions contained in the order.
Exactly. Well, my Lord, you could read that in two ways. One is that he has a sort of... He must act on the recommendation, but he can also do certain other things, as in subsection 5. Or... You read subsection 5, so to speak, as merely setting out in fuller terms a discretion which he's even got under subsection 3. But, my Lord, I'm not inviting your lordships to decide that matter now. It's unnecessary to do so at this stage for my purposes, and it may be quite an important point. But my basic point is, on the face of it, this is at the most a very residual discretion which the minister would have, and I say there's no conceivable basis for saying that the minister should not have acted upon the recommendation if he had a power. Now, my third point, and I can deal with this briefly, I'm conscious of the time, is even if a vesting order is necessary under section 174, the ground advanced by the appellants attacking it do not form a good reason in law for setting it aside. They simply don't add up to where the appellants want to get to. I say that because all the vesting order does is formalise the transfers already made under the purchase agreement and give specific protection to the depositors and third parties. It formalises the position, that is all it does. It does not, however, effect a transfer of the business. And importantly, the vesting order does not, in my submission, sanction the exclusion of the appellant's deposits. It says nothing about that. It's simply saying those depositors who've had their deposits transferred to the new bank, I'm fine with that. But it doesn't follow from that the vesting order is also saying we approve the exclusion of the appellant's deposits. And it doesn't prevent the appellants getting relief, if they're entitled to that relief, against the receiver and the central bank, that they should be covered by whatever plan they come up with. And that, I submit, is an important point. As long as the people who are included were lawfully included, there's no reason for the minister to say, I'm not going to approve this. As long as, by doing so, he's not excluding the appellants. But he's not, in my submission, excluding the appellants. That's a matter for the central bank to decide what to do if they are ordered to reconsider the matter. The second and related point...
Say that there could be, if they were ordered to reconsider the matter and they decided, all right, well, let's include the applicant's deposits, there could be a separate vesting order made. Separate
purchase transactions, separate everything.
Mr. Knox, you're going to have to really resort to bullet points because Mr. Piesky quite sensibly gave himself an extra quarter of an hour at the end, and he's going to need it in the light of the matters raised by Mr. Dennis.
Okay. Well, my Lord, if I can be very brief in that case. Secondly, it comes back to the point I adverted to at the beginning. It would serve no purpose to set aside the banking vesting order or the deposit protection trusts. It's not such an order doesn't appear to be claimed, and how could that now happen? As far as legitimate expectation is concerned, you've seen my submissions. I just want to add one brief point, and that is, it's important to bear in mind what the legitimate expectation complained about in relation to my clients is, namely the Chief Minister's speech on the 22nd of April. Now, not legitimate expectation arising by virtue of matters that occurred before the passing of the legislation. And I say that's hopeless on the facts because it is clear from first, it's clear that the Chief Minister was talking about protection of domestic depositors, and perhaps more importantly, on the 27th of April, the appellants themselves were told by the receiver, your deposits are not included. The reference for that is at, I think it's E57, Electronic Bundle 57, at paragraph 56.
Sorry, page?
57. And Electronic Bundle, page 700, in the first few paragraphs, is where you see a letter from the receiver, where he records the conversation, to the receiver, where the appellants complain about the receiver saying you're not going to be included. So I submit there can't be a legitimate expectation arising where you've been told 2 days later that you're not being included. The appellants rely upon Mr. Tackon's affidavit at paragraph 67 to 74 at Electronic Bundle 60 to 62.
Sorry, you're going to have to, if I'm going to write this down, you're going to have to give the references more slowly. Mr. Tackon at
paragraph 67 to 74.
Page?
60 to 62.
Thank you.
But all that is talking about is a legitimate expectation arising before the legislation by virtue of assurances given by the central bank about how the old banks could conduct their business. It has nothing to do with the representation said to have been made by the Chief Minister on the 22nd of April. I think the rest you'll have seen from my case. I just want to add this one point of fact. Criticism of my client that they haven't been forthcoming is unjustified. Mr. Harrigan does set out the government's position in my submission sufficient detail at E744 in his first affidavit.
744.
744.
Dr. Harrigan.
Thank you.
Sorry, Dr. Harrigan.
Does the PS.
My Lord, my lady says my submissions.
And your submissions are identical for both the Chief Minister and the Attorney General, I think?
Yes.
Yes, if we were to take the view that the government ought to remain party, then the attorney would be an appropriate respondent, would he?
I'm not sure. I think that, well...
That was an argument below.
It is an appropriate respondent.
Not
the attorney wouldn't be an appropriate respondent, I think, is our position. But we would
Exco
should be.
I'm sorry.
Exco should be the...
I think, I'm not sure, no, I think Exco would be the appropriate respondent as opposed to the Attorney General.
Right.
Right, okay.
Thank you.
Thank you very much, Mr. Knox. I appreciate you being rushed, but we're grateful. Mr. Piesky.
Lord, a few points from me in reply. Can I go back to the beginning? And Your Lordship asked me right at the beginning of the day Am I asking for the appeal to be allowed and judicial review leave to be granted, or am I asking for something more than that? And the basic answer, which I hope isn't impertinent, is at least leave. At least leave, because we have heard, particularly from the third and fourth respondents today, that they potentially have a yet further case not previously articulated, that we would need to have the right to examine carefully. And the case for candour is, if anything, intensified by what we have heard today. The point, which I'm afraid wasn't 100% clear to me, about whether an investigation actually took place and there was a finding that our deposits were not deposits, or there was a finding that they were deposits but held in foreign currency. I'm afraid we feel on this side of the room that the answers to your Lordship's question, your Ladyship's question, were unclear and were not supported by any evidence, and we are sceptical, putting it at a low level, about whether they are accurate. And we need candid disclosure of what they did decide and when. We may need to reply to that evidence. Particularly important given that the first and second respondents place such reliance on the analysis of the central bank. Just to give one small example, when it said, oh well, the books and records, once we looked at them, showed, I'm so sorry, thank you, that these were not really deposits after all, or something along those lines. Can I just give you some references? There are a large number of pages, I'm afraid, in the bundle which are accounts. You've been shown the beginning of them. But on page 499, I'm going to give 3 pages, if I may, and then I'll come to, if you like, the first. They're all very similar. 499, 577, and 663. But let's start with 499. This is one of the parents, and it's the financial statements, and it's a note to the financial statements about, quote, deposits from customers, paragraph 18, deposits from customers. And the last 2 sentences, CCIB, that's one of the appellants, has demand deposit accounts with the bank as at October 31st, 2013. Interest incurred by the bank on these deposits amounted to, and so on. Yeah. And you get the same language repeated at both of the other page references I've given, and I've given those because they are from around the time, 2013, that my learned friend said, oh well, this is when the analysis was done. And
577, I don't
577.
I don't
maybe
find
it's
it.
I'm sorry about that.
And those are
579, I'm so sorry, I was using the wrong. So 579, it's paragraph 16 to National Bank of Anguilla's 31st of March 13 statements, deposits from customers, and then, if you like, the paragraph under the table, again, 2 final sentences, PB and T, that's one of the appellants, has demand deposit accounts with the bank.
Yep.
And 663 to similar effect. But
it pays interest on the balance, according to this.
Interest, yes.
And are those figures Eastern Caribbean dollars? They must be.
Yes.
Yes, it is.
Until they are.
Yes, so at the top of the page.
Yes, thank you so much.
Yes.
So, I'm afraid every reason to doubt and no evidence to support what you have been told today. We would ask, at the very least, for leave, a finding reflecting the agreed facts that our clients did place deposits. I go that far. Our clients did place deposits because that is the fair outcome at this late stage of this application for leave, and the matter can proceed on that basis. If it turns out that the central bank refused to include our deposits because they thought they weren't deposits, then that will be an error of law. The evidence you have is sufficient. It's there also in Mr. Tacon's statement, and there has been no evidence to contradict that from the central bank or anybody else to say, no, these are not deposits. We thought they weren't deposits. We thought they weren't in the right currency. So at the very least, we say the appeal should be allowed, leave should be granted on the basis that it is simply wrong and irrational to think, if this is what they did think, that we were not depositors.
Yes. It's actually a matter, it's in paragraph 1 of the Statement of Facts and Issues, it's a matter of agreement that the appellants retained substantial deposits in Eastern Caribbean dollars.
Yes, there's a lot in this. I mean, I think I was going to go to the Statement of Fact and Issues. It's rather rare that one does. And I got a shake of the head from my lord this morning because I didn't think it was necessary, because as far as I knew, as of this morning, this was a point that hadn't been made since 2016, but here it is again.
Yeah.
Just on a point of, well, it's not detail, it is important. My lady's question about the deposits, the answer is that the first appellant had 2 deposits, one with NBA and one with CCB, and the second appellant had 1 deposit with CCB only. And if you want the reference, it's Mr. Tacon's statement, first statement, page 47 to 48 at paragraph 35.
Sorry,
Mr. Tacon's statement.
Yes.
Paragraph 35.
Page
47 to 48.
Thank you.
The other thing I would say, my lord, I don't wish this to sound like a wish list or to ask for things that we haven't really, in fairness, asked for in our grounds of appeal. But despite us having tried to explain what we seek in relation to candour, there seems to be a reluctance or an inability to understand the point. I hate to sound like I am criticising anyone personally, but we've had a response to candour in the written case which conflates the duty of candour with the duty to provide a particular document, almost completely misunderstanding the point, I'm afraid, of the duty of candour, which arises because there is no general duty to disclose documents in judicial review. That is why it is so important for public authorities to say what happened. And so I would ask, if it is only leave, rather than anything more, if leave is granted, that there should be perhaps some clear statement of what it is that the board, if I may put it this way, would expect that the third and fourth respondents in particular should do in relation to candour, perhaps by reference to some of the principles that I have attempted to show your lordships and your ladyship this morning. On a point of detail, I accept, of course, that Mr. Harrigan, Dr. Harrigan, put in an affidavit, and we would be prepared to accept that the government's stance has been more candid than the third and fourth respondents, but it has not been candid enough. They obviously know what happened, and they could have helped the court. They have the recommendation. They haven't shown it to us or to any of the courts, and that's just one example. It's not just documents, it's what happened, why were we excluded, who made the decision, and when. They must know the answer to that question, and they have still not answered it. A number of points then. I'm not going to say anything more about third and fourth respondents' position, because the submissions I made this morning will not improve by being repeated, but I did cover them effectively in some detail. The suggestion that we are excluded by operation of law, whether in relation to because you're in administration, that's absurd. Why should a person in administration not qualify? Because you're not a depositor, it's absurd for the reasons that I've shown you. Because you're not domestic, well, we are domestic. Because the Banking Act doesn't apply to you, well, I've covered that this morning. Banking Act doesn't apply to almost all of the people who did benefit. So all of the reasons given, the shifting sands of ex post facto justification, not good enough. And certainly we pass the threshold for leave against them. And in relation to the government, we say as a preliminary point, if you think, my lords, my lady, that there is an arguable case against the third and fourth respondents, it would be very strange and artificial and wrong in principle not to keep the government respondents in the case. And that's for a number of reasons, one of which is the slightly, if I may say, more acceptable approach to candour. It is possible that there will be information provided by the government respondents that for whatever reason the central bank or the receiver think that they don't have to provide, but also for substantive reasons. And this is where we come on to the points made by Mr. Knox this afternoon. The first is that he seeks to import into the Obligations Act, which of course uses just this concept of depositors, he seeks to import words used by the executive, whether it's domestic deposits or customers or so on. But you can't use a policy statement to drive the interpretation of legislation. And in any event, we were domestic depositors. That's what we were doing when we deposited funds with the parent banks. The second point, dressed up as, I would say, dressed up as a point of statutory construction, but not in fact, one, is, well, the government was only required to put in 52 million Eastern Caribbean dollars, and so the intention could not have been to cover what we now know to be what was required, which is 260 million. Well, the first problem with that, of course, which was touched on by my learned friend, but perhaps not emphasised enough, is that the 2.8 million threshold had not been identified at the time when the legislation was passed. And you don't have any definition of large depositors, so you can't actually know what is going to be required at the time of the legislation, because that's, on my learned friend case, that's a top-up provision. If, for example, the government had decided to transfer, if the government and or the receiver and or the ECCB had decided that it was possible to transfer substantially more than 2.8 million of each depositor's deposits to the NCBA, then the pressure on the DPTs would have been a lot smaller. You just don't know what the intention was. But my learned friend simply didn't address Section 6 at all, which says in terms, you have to keep it under review, you can top it up. And the critical question is who should lose out and why if there is not enough in the pot. You can't look at it and go, well, there's not in the pot, therefore you, the person with the largest sum, you couldn't have been covered. That's just not a principled way of looking at the legislation. The second point I need to just come back to, I think I have really summarised my submissions on this, is this idea that, well, we didn't challenge the vesting order in the Court of Appeal. What we were really saying, our main case, or our only case, was the judge was wrong to think that there had not been a vesting order. And I have to say, we submit that that is an absurdly formalistic and unfair approach if it's upheld. Of course we were challenging the vesting order or whatever decision any of them made which had the effect of excluding our deposits. We said in terms and repeatedly in the grounds and in the submissions that it doesn't even matter if they'd never made a decision, we would be able to challenge a failure to include. But by making decisions which we believed they had, albeit we jumped the gun effectively in thinking, assuming that you wouldn't delay 4 years or a substantial length of time in making a vesting order, they knew we were challenging what they had done. And to come to this court and say, well, the entire claim is unarguable because it's premature, because the decision alleged to have been made in the pleadings had not yet been made, but was made just before we went into the Court of Appeal, that is, I would say, unsustainable. Does the Chief Minister have a discretion? Mr. Knox says, well, 174 sub 3 assumes he will act on the recommendation. Well, with respect, no, it doesn't. It's a perfectly standard use of language in legislation, showing that the final decision is for the Minister. Mr. Knox said, well, the vesting order doesn't sanction the exclusion of our deposits. It's just saying the government is fine with whoever has been transferred. Again, that can't be right. Imagine a situation, and apologies if this sounds completely outlandish, but one does need to test the idea, a situation in which the bank, the central bank and the receiver get together and proceed on the basis that only those depositors whose names start with the letter A get to be included in the PAAs, or some other completely irrational analysis. Is it really said the Minister should sanction that by making a vesting order? If he chooses to do that, rather than by saying, I'm sorry, I think you've got that wrong, you need to reconsider, then he is also acting unlawfully, we say. My Lords, my Lady, unless there is anything further, I think those are our submissions.
I don't know if you're in a position to help me. There's quite a lot of discussion in the correspondence in the papers about whether what the appellants were calling deposits were what the receiver was calling placements. What do you understand the meaning of the word placement to be in this context?
Well, we've never understood, with great respect, because that's what led to the correspondence. There was, I think the chronology was, there was a meeting between Mr. Tackon and the receiver, and there was this suggestion, well, it's not really deposits, it's a placement. Mm-hmm. And then the letters start, quite properly I say, saying, well, if by placement you are seeking to say anything other than a deposit, we think you've made an error of law. Please, can you clarify? And there was simply nothing that came back at that point. There was no acceptance. The receiver simply didn't answer the question. So I don't really know how I can advance it. A deposit is a sum paid to a bank with a right to have it returned on demand. At least that's what a demand deposit is. It's an ordinary English word, and we would say that is what we had. Yeah. Whether or not they were also placements, I'm not sure. I don't know what a placement actually is.
Yeah.
May it please you, my lords, I rise not with the intention of replying to my learned friend's reply. I rise simply to engage your lordship's attention in respect of a question which your lordship raised for the very first time this morning, which was posed to my learned friend, to which he gave your lordships an answer, and to which I have not had an opportunity to respond. And that concerns your lordship's question as to whether you should simply address in your decision the question of whether leave should be granted, but whether you should make substantive findings. And my learned friend has invited your lordships to find as a fact that the monies with which the appellants are concerned were in fact deposits.
I don't think we are being asked to make that factual finding.
That is what I understood him to be saying, my lords.
No, Mr. Pesky will correct me if I'm wrong, but I don't think that you're asking us to make a finding in fact to that effect.
In fairness, I was asking you to consider going a little further than saying that it is arguable that we were depositors, and to make a finding that it would be irrational on the evidence that has been put forward after so much opportunity, so many opportunities, And with such little disclosure, it would have been irrational if that were the basis for the decision. That's what I have asked for, mindful of your Lordship's question. It may be that is a step too far for your Lordships, but that's as far as we think it would be appropriate to ask your Lordships, your Ladyship, to go.
Yes.
Which, I'm sorry,
Yes, yes, Mr.
which, my Lords, amount to precisely what I'm saying.
Yeah.
A finding of fact in that respect would close the door to a proper investigation of that very issue. If your Lordships were to grant leave for judicial review, then the issue would become, were the respondents correct in making a decision not to include the appellants in the resolution plan on the footing that they regarded, based on what they found, as not deposits. And that is quintessentially a matter for investigation on a substantive application for judicial review, rather than to ask your Lordships to make a finding of fact on that score in circumstances where that simply has not been fully canvassed before you.
We understand your position, Ms. Dennis. Thank you.
Obliged, my Lord.
Anything further to add, Mr. Fiske?
For me, unless I can assist with any further questions from your Lordship, your Ladyship.
Well, we're grateful to Council for their assistance. Despite the brevity of the hearing, there's an enormous amount here for us to consider. So we may well take some time to hand down or to submit our advice to His Majesty, and you'll receive a decision in due course. Take care.